They're not eating kosher like they would have with their father.
They are not.
They don't have him at all.
They don't have him in their lives day to day, no.
Because on July the 18th of 2014, he was brutally murdered in his driveway. Isn't that true?
That is true.
And you testified on direct that anybody in your family that had anything to do with it should be held responsible. Isn't that correct?
Yes.
And that includes you, doesn't it?
Anyone who's responsible.
Nothing further.
Very serious. In this video, we'll show you how, so far, 5 different people have been held accountable for the murder of FSU law professor Dan Markel back in 2014. We will show you the change of plea hearing for Luis Rivera in 2016, the verdict for Sigfredo Garcia in 2019, the verdict for Katherine Magbanua in 2022, the verdict for Charles Adelson in 2023, and the verdict for Donna Adelson. So do you think that anyone else should be held accountable in this murder? Here we go.
2016 CF 1581B. Are we ready to proceed, Mr. Collins?
Yes, Your Honor.
Okay.
This time we're going to be entering a change of plea.
All right, why don't you come forward with your clients, please?
Yes, sir.
Where do we stand, Mr. Collins?
Judge, we're entering a change of plea at this point in time. It has been reduced to writing.
Okay,
Would you like me to recite the terms?
if you would.
Yes, sir. In case number 2016 CF 1581B, in which Mr. Rivera is charged with 1 count by way of indictment with first-degree murder, he's going to withdraw any previously tendered pleas of not guilty, enter a plea of guilty to the disposition of second-degree murder, punishable by life in the Department of Corrections. The agreed upon disposition for the state is that he be adjudicated guilty on said offense, sentenced to 19 years in the Department of Corrections, with no minimum mandatory provisions. This sentence will run concurrent, although not conterminous, with the current federal sentence he's serving in the United States of America versus Rivera, Southern District of Florida, case number 1560094-CR-Conan, and that he abide by all terms set forth in Exhibit A, which is attached to this plea form. I do have a signed plea form as well as Exhibit A that has been signed by myself, Ms. Kaplan, and Mr. Rivera, and the floor is yours if I may approach.
You mind? Is that your understanding of what you're doing, Mr. Rivera?
Yes, sir.
Does that state's understand the agreement?
Yes, it is, Your Honor.
Would you swear the defendant, please?
Raise your right hand. You swear affirm testimony about giving this case to be true, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
State your name for the record, please.
Luis Manuel Rivera.
And are you currently under the influence of any alcohol, drug, or medication?
No, sir.
You've heard what Mr. Collins has indicated. Before I can accept a plea from you, I need to make sure that you are freely and voluntarily entering into that plea and that you understand what you're doing. I'm going to ask you some questions to try to clarify that. If at any point in time you do not understand what I'm asking or you have any confusion, feel free to tell me that. You're free to talk to Mr. Collins privately at any point in time. If you don't understand something I'm asking you, please be sure and clarify that with me. You understand? Yes, I'm going to advise you of some of the rights, and I'm sure Mr. Collins has gone over these with you, but I need to make them a record and make sure that you understand these things. In reference to the second-degree murder charge that you've agreed to plead to, I need to make sure you understand that you do have a right to a trial by jury. You have an absolute right to remain silent. You have a right to confront the witnesses against you. You have a right to compel the attendance of witnesses on your own behalf. You also have the right to persist in your present plea of not guilty, and if you should do so, it would be the state's job to prove your guilt to a jury beyond a reasonable doubt. You also have the right to be represented by an attorney at all stages of these proceedings. However, if your plea of no contest is accepted by the court, then you waive or give up each of these rights I've just listed. Do you understand that?
Yes, sir, I do.
You also waive, that is, you give up your right to appeal anything relating to the judgment and sentence. The only appeal that would still exist would be as to the legality of the sentence. Frankly, if I follow the plea agreement here, which I intend to do, it would be a legal sentence. So essentially, you're giving up all appeal rights. Do you understand that?
Yes, sir.
I also need to advise you that if you are not a United States citizen, this plea would result in your deportation from the United States. Do you understand that?
Yes, sir.
I also need to advise you that conviction in this case could at some later time be used to enhance your sentence if you were to go out and commit some new crime. Do you understand that?
Yes, sir.
Does he have any prior record that would relate to any type of sexual offenses, Mr. Kaufman?
No, sir.
All right. Upon your plea of no contest being accepted here today, there will not be a trial of any kind in your case. The next thing we're going to do is go on to sentencing. Do you understand that?
Yes, sir.
State, please give me a factual basis.
Judge, it's alleged that on or about July 18th, 2014, this defendant, along with his co-defendant, Rivera Garcia, traveled here to Tallahassee from the Miami area with a predetermined plan to murder Daniel Markel. They traveled to the home of Mr. Markel, located on Prescott Drive here in Tallahassee in Leon County, whereby Mr. Garcia executed Mr. Markel by shooting him 2 times in the head. This defendant was aware of that plan. He was the driver. He assisted in providing a firearm and providing transportation and to the scene of the crime and also away from the crime, as well as in other ways.
You understand if this matter were to go to trial, those are the allegations that the state would be presenting against you at trial?
Yes, sir.
And do you plead no contest to the charge of second-degree murder?
Yes, sir.
And are you entering into this plea because you believe it to be in your best interest?
Yes, sir.
The maximum penalty for this sentence is life from prison. Do you understand that maximum penalty?
Yes, I do.
I've been provided by Mr. Collins with 2 documents. One's a plea and acknowledgement of rights form. Did you sign that?
Yes, sir.
And then there's also a what's been marked as Exhibit A, a cooperation agreement. Did you also sign that document?
Yes, sir.
And did you go over those documents with Mr. Collins?
Yes, I did.
And how did you go over them with him?
You ready to?
All right. It's my understanding that you don't read real well.
Yes, sir.
All right, but he went over them carefully with you,
Yes, it is.
and you signed these documents after he read them to you.
Yes, I did.
Did he answer any questions about the agreement and the rights that you're giving up?
Yes, sir.
Do you have any questions to me about the rights you've agreed to and the agreement you've entered into?
No, sir.
The agreement calls for you to be allowed to plead to second-degree murder with an adjudication of guilt and a prison sentence of 19 years. It is not a mandatory minimum sentence. It is a regular prison sentence. It would run concurrently with the federal sentence that you're currently serving. There would be the financial obligations as set out in the plea form. You understand that's the essence of the agreement you've entered into?
Yes, sir.
You've also entered into a cooperation agreement. In that, you agree that you're going to cooperate and testify truthfully. Do you understand that?
So,
And I believe you've already made a statement to authorities. Is that correct?
yes, sir.
And in those statements, have you been truthful with them?
Yes, sir.
And do you intend to continue to be truthful with them?
Yes, sir.
You understand that if you're not truthful, that there are severe consequences that can come from your failure to be truthful or your failure to cooperate. Do you understand that?
Yes, sir.
And you've discussed that with Mr. Collins?
Yes, I have.
And you feel like you understand that?
Yes, sir.
And has anyone threatened you in any way to get you to enter into this agreement?
I'm sorry.
Has anybody promised you anything other than what has been said here in open court?
No, sir.
Do you have any questions of the court at this point in time as to the agreement you've entered into or the rights that you've given up by entering into this agreement?
No, sir.
Do you need to talk to Mr. Collins about any of this before I accept the plea?
Not at all.
And do you enter into this plea freely and voluntarily?
Yes, sir.
Feel like you understand what you're doing?
Yes, sir.
The court finds you understand the nature of the charges against you and appreciate the consequences of this plea. I find the facts the state's prepared to prove are sufficient to sustain your plea. I further find that your decision to plead no contest is freely and voluntarily made, and that you've had the advice and counsel of a competent attorney. Is there any reason not to proceed to sentencing at this time?
No, Your Honor.
Either side wish to be heard further?
No, sir.
No, Your Honor.
All right, Mr. Rivera, based upon your plea to second-degree murder, I hereby adjudicate you guilty of that offense. I sentence you to 19 years, Department of Corrections. Give you credit for 45 days already served. This sentence is to run concurrently with USA versus Rivera, case number 15-60094 out of federal court. Impose costs and fines of $2,625, $50 public defender application fee, $100 defense litigation fee, $100 cost of prosecution. Is there a request to reduce that to civil judgment?
Yes, Your Honor.
I'll reduce those amounts to civil judgment. Does that leave anything outstanding?
No, sir.
No, Your Honor.
If not, we'll be in recess.
Jury's in the courtroom.
Everybody be seated. The notes have been from you, and I see you with the verdict form in your hand. Are you our foreperson?
Yes, sir.
It's my understanding that you have reached a verdict as to one of the defendants. Is that correct?
Yes, sir.
Would you hand that verdict to the bailiff, please, sir? There should be no reaction to the verdict from anyone in the audience. If you can't abide by that, please step out. State of Florida versus Sigfredo Garcia. We, the jury, find as follows: as to count one, the defendant is guilty of first-degree murder. We, the jury, find as follows: as to count two, the defendant is guilty of conspiracy to commit first-degree murder. We, the jury, find as follows: as to count three, the defendant is not guilty. So say we all, this 11th day of October 2019. Mr. Russmeisel, did I accurately reflect the verdict of the jury?
Yes, you did, Your
All
Honor.
right. Do you wish to have the jury polled?
Yes, Judge.
All right. This is a standard procedure. I just need to confirm with each of you that what I've just announced is your individual verdict as well as the verdict of the jury as a whole. We'll do it by number. I'll start with number one. Is this your verdict as well as the verdict of the jury as a whole as to Mr. Garcia?
Yes, sir.
Number two juror?
Yes.
Number three juror?
Yes, sir.
Number four juror?
Yes.
Number five juror?
Yes.
Number six juror? Number seven juror?
Yes, sir.
Number eight juror? Number nine juror? Number 10?
Yes.
Number 11 juror?
Yes.
Number 12 juror?
Yes.
All right, the jury is unanimously confirmed the verdict. It will be filed. As to Miss Magbanua that's left, I'm going to give you an instruction on law. I would ask that you listen to my instruction as to that. I know that all of you worked hard to try to find a verdict in this case. It apparently has been impossible for you so far as to Ms. Magbanua. Sometimes an early vote before discussion can make it hard to reach an agreement about the case later. The vote, not the discussion, might make it hard to see all sides of the case. We are all aware that it is legally permissible for a jury to disagree. There are two things a jury can lawfully do: agree on a verdict or disagree on what the facts of the case may truly be. There is nothing to disagree about on the law. The law is as I told you. If you have any disagreements about the law, I should clear them up for you now. That should be my problem, not yours. If you disagree over what you believe the evidence showed, then only you can resolve that conflict if it is to be resolved. I only have one request of you. By law, I cannot demand this of you, but I want you to go back into the jury room, then taking turns, tell each of the other jurors about any weakness in your position. You should not interrupt each other or comment on each other's views until each of you has had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and will discharge you with my sincere appreciation for your services. You may now retire to continue with your deliberation.
Jury entering the courtroom.
All right, please be seated. Juror number 4, are you the foreperson? Yes, sir. And has the jury reached a verdict? Yes, sir. If you could please hand the verdict form to the bailiff. Thank you. All right, the verdict appears to be in proper form. I will now read the verdict. In the case of the state of Florida versus Katherine D. Magbanua, case number 2016 CF 3036 and 2018 CF 497, we, the jury, find as follows as to count 1. A, the defendant is guilty of first-degree murder. We, the jury, find as follows as to count 2. A, the defendant is guilty of conspiracy to commit first-degree murder. We, the jury, find as follows as to count 3. A, the defendant is guilty of solicitation to commit first-degree murder. And it is signed and dated by the foreperson. Does either party wish to have the jury polled?
Yes, Your Honor.
All right. I'm going to poll the jury, which means I'm going to go through each of you and ask if this is your true verdict and answer the court yes or no. I will use your numbers that I have for each of you, and so you answer yes or no to the question. And I start with juror number 1. Juror number 1, is this your true verdict? For your time and consideration of this difficult case, you have put in 2 long weeks of hard work. You have been punctual. You have been attentive, extremely attentive. You are a model for this community and a model for this judicial system, and I thank you very much for your service to both of those. I'm going to give you one final instruction, and that's in regards to your rights as a juror. No juror can ever be required to talk about the discussions that occurred in the jury room except by a court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. It will be up to you to decide whether to preserve your privacy as a juror. I can see that you have left your notes in the jury room. As I noted before, they will be collected and destroyed. They won't be viewed by anyone, including the court. I'm going to ask that everyone please remain in the courtroom until after the jurors have been escorted out. Again, thank you very much for your time and consideration of this case and your service to the court and the community. And you are excused. The bailiff will escort you out. Thank you very much. The jury's out of the courtroom. The door is closed. Please be seated. We're still in session. Ms. Magbanua, you have been found guilty of the 3 counts. Count 1 of first-degree murder, count 2 of the conspiracy to commit first-degree murder, and count 3 of the solicitation to commit first-degree murder. We are going to set this for sentencing, and Ms. Magbanua is entitled to a pre-sentence investigation. Are you requesting that, Mr. DeCoste?
Yes, Your Honor.
All right, so she's entitled to that. That will take approximately a month, and lately it's been taking even a little bit longer. So we will have that pre-sentence investigation ordered, and I will have that before the court. So we're going to set sentencing off for approximately 30 days, and then we'll get it scheduled. My assistant will be in touch with both parties, and we'll set for sentencing at that time. All right, Ms. Kappelman, anything else for the court?
No, Your Honor.
Anything else from the defense?
No, Your Honor.
All right, we'll be in recess then until sentencing. Thank you. Madam Clerk? Okay. But Terry, court admin is just going to get those from the jury and.
Okay, that's fine. I'm going to put those in there. Those in the box.
Okay.
Those are organized in there.
Madam Court Reporter, thank you. Thank you for saying so. Appreciate it. Good to see you. Madam Clerk, thank you. Thanks for staying late. It's nice to work with you too. See you soon. If you don't want to hang out with me, if you know that, yeah. In order to say if I should,
Everyone can be seated. They still bringing up Mr. Adelson? All right, for everyone in the gallery, once the verdict is read, if there can please be no expressions, either of shock or anger, please have no reaction at all. We're going to thank the jury for their service, and then they'll be dismissed. But again, it's very important not to either praise them or be negative concerning whatever the outcome of this is going to be. If you don't think you can control yourself, please step outside now so it does not become an issue. Jury comes in, remain seated. Everyone else, please rise. Everyone but the foreperson can be seated. Has the jury reached a unanimous verdict?
Yes, Your Honor.
If you please could hand the verdict form to the bailiff. The verdict form is in its proper order. Madam Clerk, please publish the verdict.
In the Circuit Court of the Second Judicial Circuit in and for Leon County, Florida, the state of Florida versus Charles Adelson, case number 2016 CF 3036B, verdict. Count 1. We, the jury, find as follows as to count 1 of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Count 2. We, the jury, find as follows as to count 2 of the indictment, conspiracy to commit first-degree murder. The defendant is guilty of conspiracy to commit first-degree murder. Count 3. We, the jury, find as follows as to count 3 of the indictment, solicitation to commit first-degree murder. The defendant is guilty of solicitation to commit first-degree murder. So say we all this 6th day of November, 2023.
Does the defense wish for the court to poll the jurors?
Yes, Your Honor.
Juror Moore, was your verdict and the verdict of the jury as a whole just announced?
Yes.
Juror Brazos, was your verdict and the verdict of the jury as a whole just announced?
It was.
Juror Gardner, was your verdict and the verdict of the jury as a whole just announced?
Yes.
Juror Strong, was your verdict and the verdict of the jury as a whole just announced?
Yes, sir.
Juror Kraft, was your verdict and the verdict of the jury as a whole just announced?
Yes, Your Honor.
Juror Milne, was your verdict and the verdict of the jury as a whole just announced?
Yes, sir.
Juror Hawley, was your verdict and the verdict of the jury as a whole just announced?
Yes, sir.
Juror Thorne, was your verdict and the verdict of the jury as a whole just announced?
Yes, sir.
Juror Brim, was your verdict and the verdict of the jury as a whole just announced?
Yes, sir.
Juror Williams, was your verdict and the verdict of the jury as a whole just announced?
Yes, sir.
Juror Douglas, was your verdict and the verdict of the jury as a whole just announced?
Yes, Your Honor.
Juror Platt, was your verdict and the verdict of the jury as a whole just announced?
Yes, Your Honor.
Members of the jury, I'm going to give you one last brief instruction, and from here, you will be discharged from your service. On behalf of the parties, the lawyers, and the people of the state of Florida, I want to thank you for your time and consideration of this case. I'm also going to advise you of some special privileges that are enjoyed by jurors. No juror can be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain a private affair for as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. The lawyers and their representatives are not permitted to initiate any communication with you concerning the trial. However, you may speak to the lawyers or anyone else about the trial if you desire. You also have the right to refuse to speak with anyone. A request may come from those who are simply curious or from those who might seek to find fault with this decision. It will be up to you to decide whether to preserve your privacy as a juror. We give you our sincere thanks for the work that you have performed over this 2-week trial. You are discharged. Have a wonderful evening. Everyone may be seated. Mr. Adelson, you are going to be remanded pending sentencing at this time. Does the defense wish to have a pre-sentence investigation report prepared as to counts 2 and 3?
Yes, Your Honor.
Very well. The court will order that the pre-sentence investigation be prepared by the Department of Corrections. I believe it will take possibly a month. I'm not sure if it will take longer than that. From there, will the parties be prepared to move into sentencing? Tracy, does it mind?
We're not prepared to present victim impact tonight, but as you know, the family members have traveled a great distance, so we're hoping Your Honor will permit them to appear and make those statements by Zoom whenever we're reconvening for sentencing.
That will be permitted. Anyone who wishes to provide testimony for the sentencing portion may do so over Zoom. I believe this does not implicate any right of confrontation unless the defense has something to raise concerning that matter.
No, Your Honor.
Very well. We are in recess at this point. Oh, yes. We are going to wait until the jurors have vacated the courthouse, and from there, everyone will be dismissed. Let's go ahead and set a case management date as a status. This will ensure that we have the PSI in place. That will be on December 12th at 2:30 in the afternoon. If everything is prepared, we can go ahead and have the final disposition on that day as well.
Yes, Your Honor.
Have a good night, everyone. Before the jurors are brought in and the verdict is published, I want to make sure everyone understands whatever the verdict will be in this case. I do not want there to be any gesturing or anyone making any movements that you either agree or disagree with the verdict. We are going to respect what the jury's decision is, and we are not going to subject them to any displays of emotion, whether it be from the gallery or the parties. If anyone believes they are not capable of following this instruction, I'd ask you to step outside at this time. Mrs. Adelson also as well, once the verdict is read, again, I'm going to advise you, do not have any displays of emotion as best you can. You are to control yourself. Do you understand? party have anything that needs to be addressed before the jurors are brought in? There you are. Please bring in the jurors. Please remain seated when the jurors come in this particular time. If the jury foreperson could please rise. Has the jury reached a unanimous verdict?
Yeah.
If you please can hand the verdict form to the bailiff. Having reviewed the verdict form, it is in its proper order. At this time, I will publish the verdict. We, the jury, find as follows as to count 1 of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself. Count 2. We, the jury, find as follows as to count 2 of the indictment. Conspiracy to commit first-degree murder. The defendant is guilty of conspiracy to commit first-degree murder. Count 3. We, the jury, find as follows as to count 3 of the indictment. Solicitation to commit first-degree murder. The defendant is guilty of solicitation to commit first-degree murder. And it is signed and dated by the foreperson. One moment. Members of the jury, the bailiff will escort you to the jury room. Mrs. Adelson, while this was not the outcome I'm sure that you desired, there will not be any further outbursts in front of the jury. If you cannot control yourself, I am going to have to determine if you will be removed from the remainder of this process. Do you understand what I'm saying to you?
Yes.
Do you need a moment to collect yourself? Before the jurors are brought back in, we will take a brief 2-minute break. Please give her tissues if she needs them.
Judgment for with an impact to the defense and to your honor.
When the jurors are brought back into the room, does the defense wish to have the jurors polled before they are discharged?
Yes, Your Honor.
Very well. Please bring back in the jurors so we can conclude with their portion of the trial. Members of the jury, before I discharge you for this evening, I am briefly going to poll you concerning whether your verdict is unanimous at the request of one of the parties. When you hear your last name, please appropriately respond. Give to you before you are discharged. Please listen carefully. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges that are enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. With that being said, I want to extend my thanks on behalf of the entire Second Circuit for your service in this matter. You are discharged. Have a good evening. As to the jury's verdict, with the jury having found the defendant guilty of the 3 charges of the indictment, is the defense asking for a pre-sentence report on counts 2 and 3. As to count 1, the penalty is statutory, and essentially there is no modification for it.
Yes, Your Honor.
Well, pre-sentence investigation and report is ordered by the court as to counts 2 and 3. As to count 1, is there any reason why we cannot proceed to sentencing on this matter?
Your Honor, we would request an opportunity to ensure that our client is okay before we proceed to sentencing. It's my understanding that Charlie Adelson wasn't sentenced right away. We're asking for the same purpose.
Very well. The court then will set a separate sentencing date.
May I inquire whether the family members that are present would like to give victim impact now or at the future date?
Go ahead.
on to go to impact statements this evening.
It's fine. Right there in front of the lectern.
Watch your step. You have your step back.
If you please can identify yourself for the record.
Yes, my name is Ruth Mark.
That way, 'cause you're
Sorry?
I'm worried you're gonna trip. Just
Okay,
that's fine.
I already did. My name is Ruth Markel.
You may give your impact statement, ma'am.
Thank you, Judge Everett. To the Honorable Judge Everett, my name is Ruth Markel. I am the mother of the late Dan Markel. I stand before you today to express the profound sadness and grief that Dan's family and I have endured since his tragic murder. We have lost a treasure. My son Dan's life was cut tragically short at 41 years old. For 11 years, we have been forced to a life filled with unimaginable pain and heartbreak. Dan's father, Phil, and his sister, Shelley, share in this unending sorrow. Dan was a devoted father, brother, and son. Dan's life was marked by his devotion to family, education, and community. He was a loving, caring, and inspiring person. His academic journey included studying politics and philosophy at Harvard University, earning a master's degree later in political theory from the Hebrew University of Jerusalem and Emmanuel College in Cambridge, and later going back to Harvard to get a law degree. Dan was a prolific scholar and did start, co-founded the influential Prof's blog. His energy, drive, and sociability greatly enriched the FSU College of Law. Dan's life was filled with passion, music, dance, sports, travel, and people. But of all my son's accomplishments, however, I am most proud of the devoted father Danny was to his two sons, Benjamin and Lincoln. Dan was present, loving, and supportive, always putting his children's well-being first. He regularly attended the boys' daycares, reading with them. His office was filled with their drawings, and his home, his living room, filled with their toys. Dan was the boys' hero, and they have been forced to grow up without a father. Dan's murder has shattered our family and caused deep permanent pain. This was a particularly senseless crime, and the murder was particularly insensible. It was not revenge. Dan was a law-abiding and respectful citizen, an active father, and a living son. His life was devoted to teaching and helping others. The pain and suffering of Dan's murder goes well beyond other families too. That is why I wrote the book, The Unveiling, a mother's reflection on murder, grief, and trial life. In my unrelenting grief, I turned to advocacy, to feel purpose, and to help others with these tragic losses. I have found meaning and comfort to connect with others who want to serve justice. To all the community of journalists, TV programs, podcasters, Tallahassee communities, and the allies who have put their hearts in keeping Danny's story alive, we are full of thanks. To law enforcement and prosecutors, our gratitude is beyond for their dedicated, careful perseverance in seeking justice for Danny and our family. If Tallahassee is known for football, Tallahassee should be known for the prosecution and for law enforcement. They have done an outstanding job. These extraordinary efforts underscore the brutal truth of our family's story. Danny's murder was orchestrated by his former mother-in-law, Donna Adelson, and other co-conspirators, and is a crime of cruelty. It is a murder of grief, a murder of selfishly prioritizing one's own desires over what is just or right. And at its core, this was a murder of convenience. So that one grandmother could live closer to her grandchildren, she killed their father and ripped the children from the other grandparents' lives. Donna Adelson's crimes against Dan began long before his murder. She belittled Dan in front of his children. She spread lies about it and contributed to a brutal separation between Dan and Wendy. She rented the house. And Dan came home and he found that Wendy and the boys were gone with most of their belongings. He called this devastation Pearl Harbor. Donna's eagerness for Wendy to divorce Dan and to relocate to South Florida led her to increasingly devise desperate schemes. Despite these efforts, the court ruled that Wendy could not move the boys away from their loving father. Failing to achieve her goal through legal means, Donna finally resorted to orchestrating Dan's murder. She plotted, planned, and paid for his murder. Donna's crimes led to further devastation. Her middle son, Charlie, was convicted and sentenced to a life in prison for his role in facilitating Danny's murder for hire. Can you imagine a mother involving a son to complete a murder? Donna's eldest son, Rob, an honest and decent man, is estranged from the family. And her younger child, Wendy, has decided once again to relocate to another state. Her actions and those of her co-conspirators have caused children to lose their parents. Katherine Magbanua, Rivera, Garcia, and Charlie Adelson, also convicted, are all convicted for life and have lost access to their children. Prior to her arrest, Donna's recorded phone calls with Charlie reveal their lack of a moral compass or capacity for self-reflection. She blames external forces for her family's curse. They're outside of her, but she is the curse, and lashes out angrily at witnesses who took the brave step to testify. Her modus operandi has always been to run from Tallahassee and then to try to flee to Vietnam. For our family, there is no such prospect for escape. Danny's absence, and that leaves a hole at the center of our lives, no matter where we go. Yet Dan's murder was not enough for Donna. His death was not enough. Danny had to be fully erased from his beloved sons. The boy's last name was ever changed, an extraordinary decision to excise the Markel name from Phil's only grandsons who shared his last name. And after the first arrests were made, Donna didn't allow the Markel family to have access for over 6 years. It was only when there was a phenomenal Tallahassee advocacy group that passed the Markel Act. The passage of this bill was immediately followed by our first invitation to see the boys after the arrest. The door only cracked open. Despite these efforts, we remain excluded from the boys' lives. We were not at their bar mitzvahs or graduations. We have extremely highly choreographed visits and communications. We only wait for the day that Benjamin and Lincoln will visit their father and his grave in his father's history and his grave in Toronto. We want nothing more. The facts of Danny's murder, are difficult to swallow. The experiences Phil, Shelley, and I have been forced to suffer are profound as homicide survivors and victims of the criminal system. The lives of Danny's 2 sons, our grandchildren, were forever turned upside down by this crime. Benjamin and Lincoln were only preschoolers when their father was murdered, and now they are forced to confront and try to understand the unthinkable crimes of murder and the Adelsons' involvement. Our lives will never return to normal. For those who loved Danny and for those who Danny loved, there is no escape from the wicked effects of what Donna Adelson set in motion, carried out, and paid for, and for many years enjoyed the aftermath of. Donna Adelson has caused immense devastation and an untimely, undeserved murder through her actions. While no trial or verdict can ever heal the profound wounds caused by Dan's murder, justice must be served. I respectfully ask the court to impose the maximum sentence on Donna Adelson. Her lack of cooperation and remorse throughout the case demands justice, the justice that Dan's life and memory fully deserve. We are immensely grateful to the court for its careful and compassionate deliberation. Respectively, Ruth Markel.
Thank you, Ms. Markel. Are there any other victim impact statements this evening? If you please could tell us your name for the record.
Good evening. My name is Phil Markel. I'm Danny's father. Judge Everett, I appreciate the opportunity to speak about the impact of Donna Adelson's actions on my families and the families of so many others. While this victim impact statement is addressed to you, Your Honor, it is also intended for the Adelson family, Harvey, Charlie, Wendy, and particularly Donna. I would like them to understand and reflect on the deep and irreparable damage they have caused. The pain that they have caused my family is obvious and permanent, but they have also caused lifelong harm to their own immediate family and so many other families and children around. Donna's selfishness, cruelty, and complete disrespect for human life, along with that of her co-conspirators, have left families forever broken. Louis Rivera, his children have no father. Katherine Magbanua and Sigfredo Garcia, their children have no parents. Charlie Adelson, his son, Roman, has no father. Rob Adelson and his wife and their 2 children have lost their uncle and grandparents. Shelley and Ian, my daughter, their 3 children, my grandchildren, are left without an uncle and are separated from their cousins. Of course, their heinous and callous actions have left me, Ruth, and Shelley without our Danny, and Ben and Lincoln without their father. For anyone to commit such a cold-blooded, unprovoked act of murder is horrific. For Donna, someone who claims to care so much about Ben and Lincoln, her sun shines. Her actions are beyond comprehension. She has harmed forever the people she claims to have loved. In the Jewish custom, we have an expression to always wish others to live to 120 years of age. For Donna, I wish her to live to 120, alone in her jail cell. I wish that every day of her remaining days she thinks about the harm she has caused to so many, especially those 2 boys she claims to have loved so much. For these reasons, Your Honor, I ask the court sentence Donna Adelson to the maximum possible sentence. And my only short question to Donna, was it worth it? Respectfully, thank you.
Thank you, Mr. Markel. Are there any other matters that the court needs to address this evening, Ms. Koppelman? With the PSI being ordered, the court will pronounce the sentence as to counts 2 and 3 after it's been completed. The parties have had an opportunity to review the pre-sentence investigation report and make any objections if they believe they need to. As to the 3 counts that the jury has found the defendant guilty of, I will adjudicate her guilty at this time, but sentence will be pronounced as to the 3 counts at a later date. She is remanded for sentencing at this time. Lieutenant Henry, please notify the commander at the jail that the appropriate screening needs to take place to ensure that the defendant is in an area where she is not subject to any self-harm. For a case management date coming up, what would the parties request?
Ms. Dugan's October 4th day, Your Honor.
Believe that is 10/14. Is that correct, Ms. Dugan?
Yes, sir.
October 14th for case management at 2:30 p.m. That will be in the normal courtroom, 3B. Patricia, if you can make sure that the notice goes to DOC so they are aware that the PSI needs to be completed as soon as possible. Thank you. We are in recess at this time. We will reconvene on October 14th. Have a good evening, everyone.
Thank you for watching today's deep dive. If you found this case interesting or have any thoughts, feel free to leave a comment below. Remember, this community thrives on smart and respectful discussion. Don't forget to like, subscribe, and hit the bell to stay on track with our new case videos. We cover new details, court hearings, interviews, interrogations, and more. This is Maya with Deep Dive True Crime and Mentor Lawyer Justice Network, and I'll see you all in the next video.